Well, good afternoon. Thank you for being here and joining us today. And I am so proud of the work that my caucus colleague, particularly Rod Fox, and there have been others, Gary Bickman is here as well, have done to bring us to the point that we're now at today. I'd also like to thank MP Jim Hillyer for his efforts in this motion as also. It's been a truly excellent example of coming together to get things done for Albertans, and both of these parliamentarians have done tremendous work on this issue. We're here today unified as federal and provincial allies to stand up for property rights in Alberta. I got into politics in part to protect property rights. I believe they are the foundation of liberty, and they must be upheld for individuals to be safeguarded against government actions. Here in Alberta, property rights have been an issue of some controversy. In recent years, Alberta landowners have been subjected to some of the most regressive property legislation ever conceived. This suite of laws passed in record time with little or no consultation trampled on fundamental rights to title, use, and enjoyment of property, except in accordance with law for full, just, and timely compensation. The uproar from landowners was swift and forceful. In the days and years that followed, these laws have been criticized by scholars and experts to the point that some have been amended and others have been repealed, but only after they've inflicted their damage. The truth is, if the Canadian Constitution, the Charter of Rights and Freedoms, included protection for property rights, laws like the one foisted on Alberta landowners likely never would have seen the light of day. But the Charter doesn't guarantee property rights, and in the absence of that guarantee, these laws were passed with little or no recourse for property owners. We're here this afternoon to change all of that. In the upcoming legislative session, my colleague Rod Fox, MLA for Lacombe-Ponoka, will introduce a private member's motion, Motion 501, entrenching property rights for Alberta in the Constitution. As its title suggests, the motion calls for the legislature to authorize an amendment to the Constitution to fully enshrine property rights in Alberta in the Charter of Rights and Freedoms. Mr. Hillyer, the Member of Parliament for Lethbridge, has introduced the same motion in the House of Commons and will bring it forward to the floor of the House for a ratifying vote should the Alberta legislature pass Rod Fox's motion 501. If Mr. Hillyer's motion passes, both the House and the Senate, property rights in Alberta would be enshrined in the Canadian Charter of Rights and Freedoms. As you can see, this is an historic opportunity to demonstrate Alberta's commitment to property rights and make a tangible impact that would give landowners the protection that they deserve. And I sincerely hope that members of the Alberta legislature as well as the House of Commons will recognize this tremendous opportunity to see that both motions pass with resounding support. I also want to acknowledge the efforts of Grassroots Alberta, a group of Alberta landowners who today released their own proposals to strengthen property rights in Alberta. They have put forward a series of suggestions for how some of the bad bills that were passed over the last few years can be fixed. But what our motion would do would make sure that these kinds of bad bills can never be passed again. Together, our two initiatives will, if implemented, reverse the Alberta government's flawed legislation and make sure that no similar laws will again pass. I think our efforts show a real desire for fundamental changes in how our property is protected from unfair government action. And I'll now turn it over to Rod and then to Jim to talk about their initiatives.
Thank you very much, Danielle. Motion 501 is a tremendous opportunity for Alberta to lead the way and entrench a fundamental right into our federal constitution, a right that has been missing for far too long. Through this change, landowner rights for Albertans would be protected by the highest law in the land, the Canadian Charter. These rights would apply to the land, leases, permits, licenses, statutory consents, and anything related to the use of the land. There is a clear need for a move like this in Alberta. Recent provincial legislation has eroded the rights of landowners in our province by giving broad discretionary powers to the government on deciding the fate of private land and compensation practices in expropriation cases. This change would act in concert with a federal motion introduced by MP Jim Hillyer. In one stroke, it ensures that the current Alberta government and any future Alberta governments are made to respect the rights of landowners by cementing those rights in the federal constitution. To be clear, this amendment would not fall under the 5070 clause of the Constitution, but would be done through Section 43 of the amending formula. Section 43 states that if a constitutional amendment applies to one or more provinces, but not all of them, the amendment requires only the resolutions of support by the Senate, the House of Commons, and of the Legislative Assembly of each province where the amendment applies. Since 1982, there have been 7 amendments enacted using the Section 43 formula. Thanks to the work of Mr. Hillyer, through Motion 520 in the Federal House of Commons, and with the passing of Motion 501 in the Alberta Legislature, it will mean we are one step closer to enshrining property rights for all Albertans in the Canadian Charter. I trust any member of the Alberta Legislature who is seriously interested in restoring property rights in Alberta will stand with myself, with MP Hillyer, with our caucus, and support Motion 501 in the upcoming legislative session. With that, I will turn the mic over to Mr. Hillyer, who will walk everyone through the work he is doing on the federal stage.
Thank you very much, Danielle and Rod. And before I get too deep into my words, I also want to thank Gary Bickman. I actually grew up 2 houses away from Gary, going to school with his kids. And when I was going to university, he hosted a monthly discussion group about politics, constitutional law, political economy. The only rule was you couldn't discuss politics. You could only discuss politics, meaning we didn't want to get partisan. And we talked about this very stuff back then before either of us were elected to him in the legislature, me in Parliament. And so this is a long time coming, not just for us, but for the country. I was a teenager when I first learned that property rights were not included in the Charter of Rights and Freedoms. And even at that age, I recognized that the omission of property rights not only could open the door to injustice, but its omission was an injustice in itself. The fight for property rights is a fight worth fighting, and more importantly, it is a fight worth winning. As we've talked about, prime ministers and parties have been unable to acquire the necessary support to amend the Constitution through the general amending formula. It's been attempted many times to include property rights into the Charter of Rights and Freedoms by various prime ministers, governments, parliaments of different parties. But they have failed, and most people agree that today there is no appetite for a debate on general constitutional reform. So we're taking a more likely approach. We have taken on the giant of constitutionally protecting the property rights by the means of the smooth stone of Section 43. On June 11th, I introduced Motion 520 to Parliament that it was a resolution to add property rights to the Charter of Rights and Freedoms in Alberta. As governments have a history of using regulations as a way of avoiding directly confiscating the property, this resolution also protects not just the ownership of property, but the enjoyment of that property. Alberta's property rights advocate Lee Cutforth has correctly argued that property rights are part of our Constitution already because our Constitution includes an unwritten part based on common law, which is simply the way we've done things for hundreds of years, ways that have been proven to work, and ways that satisfy a universal sense of justice. The Charter itself also makes clear that just because a right isn't in the Charter, it doesn't mean that right doesn't exist. But more and more, the standards of justifications is it technically legal rather than is it just? The standard of justification has become legality rather than justice itself. Because property rights aren't included in the written part of the Constitution, things like the Manitoba Court of Appeal in 1999 told farmers who are challenging the Canada Wheat Board that the right to enjoy property wasn't even a fundamental part of Canadian society, even though it's in the Bill of Rights. Our heritage of human rights is grounded on the understanding that there's a set of basic human rights that are fundamental and universal. While they can be violated, they cannot be given or taken away. They simply are. They are natural rights. They are God-given rights or inalienable rights. When the nobles compelled the king to sign the Magna Carta in 1215, they were not asking the king to grant them those rights. Rather, it was a not-so-gentle reminder that they already had those rights and that the king himself could not violate them. That was almost 1,000 years ago. And people were telling the government that the days were long past when rulers simply can seize what they want. The notion that governments can strip away The value of private land without compensation was outdated then, and it certainly has no place in Canada in the 21st century. Canada has a heritage of a respect for basic human rights, personal freedoms, and the rule of law. And we have a rich history of documents affirming these rights, such as the Magna Carta of 2015, the Canadian Bill of Rights, the Charter of Rights and Freedoms itself. Property rights are fundamental and should have been included in the Charter in 1982. With the passings of motions 501 and 520, we can right this wrong. Political posturing is what prevented it from being included in 1982. And I encourage all members of the legislature and of the House of Commons to take this opportunity to be more than just politicians and become statesmen. Whatever we choose, we cannot escape making history. We can be the ones who restore property rights to our defining documents and restoring this fundamental freedom to the people. Thank you.
Excellent. Thanks, Jim. Don't know if you had any questions? Any questions for you?
Is there a touchstone example you could give us, or something that kind of has sparked this?
There's 5 pieces of legislation that actually sparked this, and they're very well known in the rural community. Bill 19, the Land Assembly Project Areas Act; Bill 36, the Land Stewardship Act; Bill 24, the Carbon Capture and Storage Amendment Act; Bill 50, the Electric Statutes Amendment Act; and Bill 2, the Responsible Energy Act. All 5 of those bills, in one way or another, limited property use or paved the way for government to be able to cancel leases without proper compensation or due recourse. This is part of the reason why we've had such a huge backlash in the rural areas against some of the actions of government. And to his credit, Mr. Prentice has said that he intends to address this. We believe that the motion that Mr. Hillyer is putting forward, the motion that Mr. Fox is putting forward, begins the process of trying to correct and make sure that these kinds of pieces of legislation never get passed again. The group that we mentioned earlier, Grassroots for Alberta, has put forward a very comprehensive document on how those 5 bills I just mentioned can be fixed. And I think that in combination, those 2 things give the challenge to Mr. Prentice, that if he actually is serious about meeting his commitment during the election, and we hope he is, that this is the path forward for how to do it. And we're hopeful that we'll be able to get multi-partisan support for this effort. All right.
Can we just change gears one
Sure.
time? We just wanted to ask you about tobacco and the upcoming, the Conservatives want to put a ban on flavored tobacco.
Yeah.
What's your reaction?
We always have free votes in the legislature in our party, and I can tell you that you'll likely see Wildrose caucus members split on the issue. There are some who feel very strongly that is the right thing to do, and others who feel that it's a step too far. So if it comes forward in the legislature, we'll debate it as a caucus, but I would anticipate that you'll find that Wildrose ends up having a split position, that we've got different MLAs who take a different position on it, depending on what they think will make the most sense in their areas. All right. Did you have anything? You're good? Excellent. Thanks a lot for coming today.
Thank you.